Be ready? Start. First of all, from the pleadings as well as evidence of the parties, the factum of parties being in domestic relationship with each other, whether they are residing in the shared household together after the marriage in the past and presently not residing at her matrimonial house are to be proved. Stop. Then comes the question of commission of domestic violence upon the applicant by the respondents. Stop. Upon this aspect, no doubt, CW1 applicant Roma Devi has deposed that soon after death of her husband and even before his death, the behavior of respondents was not good and they used to taunt her for not bringing sufficient dowry. Stop. She further deposed on the factum of her severely beaten by the respondents many times and leaving from the matrimonial house after retaining the Istidhan articles of complainant. Stop. Similar in the version of CW2 Priyanka, who corroborated the version of complainant CW1. Stop. But the analysis of the whole evidence has led this court to the conclusion that they are only general and vague allegations of bad behavior of the respondents' demand of dowry and severe beatings many times without any specification of particular as when. Stop. How, in what manner, in whose presence, from whom or to whom demand of dowry advanced and by which of the respondents. Stop. Further, no specific day, time and place of many times severe beatings by the respondents and in what manner by which instrument beatings were effected upon the applicant. Stop. Admittedly, no complaint or medical examination of the applicant despite of fact of her suffering from multiple injuries when she was allegedly left at parental home by the respondents. Stop. Simple allegations of taunting without any specification of any particular instances are of no avail to the applicant. Stop. Under such factual circumstances, there remained only general and vague allegations of demands of dowry and consequent domestic violence upon the applicant. Stop. Except self-servicing statement of the applicant and verbatim retreating by her sister in general and vague terms, no sportive and corroborative evidence of domestic violence at the hands of respondents against the appellant. Stop. Stancha. As far as the allegations of snatching of her Stridhan earrings and other ornaments, again it is without any substantial basis. Stop. There are no doubts allegations of entrustment of dowry articles to husband of applicant and his family member, but no specific description as what were those articles entrusted to respondents at the time of marriage and what out of those have been retained by the respondents or they refused to return the same. Stop. Further, there is nothing regarding entrustment of any specific articles to either of respondents. Stop. Under such circumstances, the fact of entrustment of any dowry articles at the time of marriage to either of respondents remained unproved. Stop. If so, the question of their retention or refusal to return to the applicant does not arise. Stop. Stancha. Though the domestic incidents report of the protection officer on record shows the incidences of domestic violence in the form of physical, verbal and emotional, economic violence and dowry related harassment, but like deposition of the applicant petitioner, there are no specific incidences of any domestic violence recorded in the DIR. Stop. In absence of deposition before the court by the petitioner and non-mentioning of any specific act of violence on specific point of time in the DIR, this court is not in position to correlate the testimony of the petitioner with the DIR stop. Under such circumstances, the DIR cannot considered as reliable and true account of domestic violence stop. Even if the DIR is considered as true factual presentation of domestic violence incidences, then it is not in conformity with the deposition of the applicant petitioner stop stranger. Further, in cross-examination, petitioner deposed that she do not remember what is the school fee of her children and Inderdev had deposited the school fee. Thereafter, self-deposed that this time it was deposited by her staff. Further, in cross-examination, deposed that her and her father-in-law's house are same and in between there is a wall stop. Further, deposed that before death of her husband, electric bill used to come in name of her husband stop. Further, deposed that she is having a ration card, but in her ration card there is no name of her father-in-law and mother-in-law stop. Further, deposed that she is having a separate ration card stop. Further, admitted the suggestion as correct that from the time of lifetime of her husband she was having separate residence as well as separate kitchen from her father-in-law stop. So from the aforesaid deposition of petitioner itself, as she was having separate residence and kitchen since lifetime of her husband from the respondents, and there is a wall between the respective houses of the parties and separate ration card, same puts a question mark on the existence of a domestic relation between the parties to the present case stop stranger. In a nutshell, from the evidence on records, the commission of domestic violence upon the petitioner by the respondents at any point of time has not been proved stop. All allegations being vague and general lead to conclusion of commission of no domestic violence upon the petitioner by the respondent stop stranger. Further, she claimed her share and right to reside in the shared household as well as monetary relief in the form of residence allowance of rupees 5,000 per month, monthly allowance of rupees 20,000 from respondents towards physical, mental and financial loss stop. These claims remained without any justification or rational basis stop. Regarding claim of monthly maintenance allowance from respondents, firstly, no justification for claim of rupees 20,000 per month, and secondly, no legal basis of claim of maintenance from respondents, especially in absence of proof of any income from the property of her deceased husband stop. Nextly, in absence of proof of domestic violence, the question of monetary compensation on account of physical or mental or financial loss does not arise stop. Further, regarding returning of Stridhan of the applicant, in absence of proof of any entrustment or retention of any specific Stridhan, this court is not in position to order so stop. There is no specific mention of description of the Stridhan articles retained by the respondents stop. In absence of it, no general order is justified stop stanza. Lastly, in factual circumstances of the case, this court prima facie remained unsatisfied on the aspects of taking place of any domestic violence or likelihood of domestic violence upon the applicant petitioner by the respondents stop. Resultantly, no relief is warranted under the Act stop. So the petitioner is not entitled to any order of relief under the Act stop. Further, my view also found support from case law as relied by respondents side mentioned at initial rate of para number 6 stop. In view of the aforesaid discussion, the petition application is hereby dismissed stop. Copy of judgment be given to parties to application and officer in charge of concerned police station free of cost in in compliance of provisions contained in Section 24 of the Act stop stanza. Challenge in this appeal is the judgment of the learned single judge of the Patna High Court holding that the appellants were not entitled to a decree for specific performance of contract stop. In a second appeal filed by the respondent, the judgment and decree of the trial court as affirmed by the first appellate court were reversed and the suit of the stop over.